we don't really see stuff with regard to ammunition until the 1900s.
No, I'm sorry. I like had a moment because all I could hear was the keyboards clicking about like these stupid lawyers don't know what shall not be infringed
I know
means.
what shall means most of the time.
No, we know, but we are the Armed Attorneys. Today we are answering the question that is on everyone's mind. Did the body snatchers come for the Ninth Circuit? Because we've got another gigantic 2A win we're going to talk about today. What case just got decided? What does it mean for the future of ammunition in California? And what is the state of California going to do next to try to undo this win? But before we get started, show your support for the Second Amendment by hitting the like button.
And this harkens back to 2016 when we had a ballot measure in the state of California that sought to restrict ammunition sales to being in person and required a background check.
The people voted for this. The people.
Yeah.
It was Proposition 63.
Yeah.
Like that just shocks me. But okay, sorry. Go on.
Yeah, well, enter Olympian and skeet shooter Rhodes, Kim Rhodes. She said, hey, guess what? You know, obviously this is an interference with the Second Amendment. This is interfering with my Second Amendment rights. This whole little scheme looks unconstitutional, and she filed suit.
Yes. So this is the ballot measure went into effect as California Penal Code 30312A and B. It took effect in 2019. It is, reading the code as an attorney, terrible, highly confusing. Having the Ninth Circuit try to explain it to me in their opinion, terrible, highly confusing. I mean, did you actually get a good feel for all of these like 4 different background check measures and exactly how it's conducted?
No, well,
I didn't either.
Well, and we've been dealing with the state of California a little bit more than I like to lately. And the way that we were just trying to get a document from LA the other day, and they have like 26 courts spread out all over the city, and it was just it's already confusing by all get out. And then when they have these kind of crazy laws injected into their already crazy system, it really is a nightmare hellscape that I don't invite upon anyone.
No, I'll stick to being a Texas lawyer because this really was awful. So I am not even going to, I do not think it is worth it to try to walk through the methods of ammunition background check that are laid out in the California Penal Code. I think that we can just suffice to say that it is restrictive, not only financially, because all of these methods require payments to the government, additional payments, so that you can have the privilege of getting your background checked to buy ammunition.
A payment to the store itself if they're, if they have a processing fee.
Correct. And it's going to require extra time because even though not all of these 4 ammunition purchase background check options require extra time, there is no time limitation on how long the government can stop you from purchasing your ammunition as they go through this check. So we've got the time limits and we've got the monies.
Well, and I just go back to the in-person stuff. I mean, because for most of us across the United States, we can buy ammunition online, have it shipped directly to our house, which is pretty convenient.
Sure.
But not in California.
No, that is the only way I can get ammo for one of my handguns.
Yeah.
Because it is so unusual.
Well,
like, what would I do? What would
I
I
guess
do?
you could theoretically purchase it and have it shipped to a gun store, but then they would facilitate the transfer with their California background. We don't.
I mean,
need
that's what they have to do right now, but
we,
absurd.
So what happened? All right, we had a district court in the state of California issue a permanent injunction against the state of California for enforcing this kind of ammunition background license, scheme.
Well, I mean, let's go even back further than that.
Okay.
I mean, I think it's worth the whole detailed history, which is that the district court issues preliminary injunction.
Yep.
Gets appealed to the Ninth Circuit. And
remember, I guess that is fun to talk
about. I mean, this started 7 years ago.
Yeah.
Because they filed suit before the law actually went into effect. They made a facial constitutional challenge and an as-applied constitutional challenge. They challenged on the basis of Second Amendment grounds. They challenged on the basis of dormant commerce clause.
Yeah, preemption.
Yeah, and the preemption one was the most interesting.
Yeah.
Saying that essentially the Firearm Owners Protection Act preempted this law because it says that you're allowed to take ammunition in and out of hostile states and that the state of California has no business regulating in this field. Very interesting. But They take it up to the Ninth Circuit. Ninth Circuit, of course, because all these things take a very, very long time. In the course of the Ninth Circuit, actually, I suppose, reviewing this case, it is vacated by Bruen.
Yeah, so we have New York State Rifle and Pistol Association v. Bruen. This is our Supreme Court case from June of 2022, and it's our standard by which we judge Second Amendment infringements. And I mean, going forward, I mean, maybe we sound like a broken record, but it's so stinking important because this is the framework that all of these courts, when they're looking at Second Amendment infringements, this is theoretically what they need to be applying.
Yes. So we have, I mean, good initial decision out of the district court, a win, up to the Ninth Circuit. Ninth Circuit says we're going to vacate what you've already done. We're going to send it back down to you, district court, and you need to reevaluate this in light of Bruen, which seems counterintuitive because the decision will remain favorable, but it just is. It's what
It's called dragging your feet, California.
It's called dragging your feet. So district court does what they are allowed to do. They actually consider the injunction and they mesh it in with the trial on the merits, issue a permanent injunction, which then gets appealed to the Ninth Circuit. And here we are 7 years after suit, and the Ninth Circuit has, we're about halfway through the process, but they've affirmed.
Yes, so, and we'll throw this case up on screen in case you want to go read the opinion. It's Rhodes v. Bonta. It's case number 24542, Ninth Circuit. This was decided July the 24th, 2025. So we have a 3-judge panel. We have 2 judges saying, yes, we affirm the lower court's decision, this decision of a permanent injunction restraining California from enforcing this background check and scheme with regard to ammunition. We got a dissenter. Obviously, you can imagine that kind of stuff in the Ninth Circuit. But it's not the end of the story, but let's talk about the opinion first.
Yes, so we do sort of your standard Bruen analysis. Of course, the first thing the government wants to do is say this isn't a Bruen issue, right? That's
sidestep it.
Right. That's always there. That's always their issue. And the Ninth Circuit really slaps that down pretty quickly and says, no. I mean, in fact, Heller says you have the right to operable arms, right? That's all that Heller was about, right?
Yeah, so don't even get to Bruen yet.
No. So yes, in order to be operable, you have to have ammunition, or else it's a club, a less effective club.
Yeah.
So great. But then we go through sort of our next step analysis, which is, okay, this is a constraint on the Second Amendment. Is there a historical analog?
Well, they kind of go through this, and really, when we're talking about, the framework from New York State Rifle and Pistol Association, we're looking at the time of the adoption of the Second Amendment in 1791. So, was there a law, a regulation, or something at the founding of the country that would support or justify this infringement to the Second Amendment? Because really, the founders put this stuff in writing. What did they mean by all these things? Well, if they say shall not be infringed, that seems pretty clear to me. But we still saw infringements to the Second Amendment at the time of the founding. So the arguments the courts are adopting here is, okay, well, there is some wiggle room here. I think it's very, very small. But our window for infringements, we're really looking around the 1791 era. We don't really see stuff with regard to ammunition till the 1900s.
No, I'm sorry. I had a moment because all I could hear was the keyboards clicking about these stupid lawyers don't know what shall not be infringed means.
I know what shall means most of the time.
No, we know. But we're here because the
courts made it really complicated.
The courts made it really complicated. That's why we have jobs, right? So
I hate that.
Here we are. I know I'd be doing something totally different. So yes, and I think actually, of course they find no historical cousin for this kind of infringement. But actually what I think is interesting that we didn't mention before is that the Ninth Circuit actually, cites quite a bit of the Ninth Circuit, as they should. I mean, you look within your circuit first. I mean, after you look at your Supreme Court precedent, and the 2 cases that they rely on sort of really heavily are 2 cases we've discussed on the channel before, one pro-gun, one anti-gun. And it's sort of the baby that they split here is really interesting because they talk about when, which we just spoke about, right? You can't meter out firearms over the course of a month and say that it's at all passes Bruen muster or that it's, consistent with the Second Amendment. But you can and this was that Texiera case, you remember, where it was
Yeah.
the zoning law case, you can, like, you don't have to tell gun people that everything is at their highest convenience, which I think you should have to do, but the Ninth Circuit says you don't. And, you know, if you want to put a zoning restriction in place, you have to drive a little further to get the gun that you want. Well, so be it. California says that that's just fine. But so they talk about those two cases and say, look, you know, this is the right to have ammunition is way more important than the right to, like, not have to drive extra time to get your gun.
Yeah, or to practice.
Yeah. So, you know, all right, I'll take it.
But this is not the end of the story. So
No.
upheld permanent injunction on these things. This was a 3-court panel. The procedure, where do we go from here? Well, the state of California could ask for an en banc review. That's when they have the entire Ninth Circuit. Usually it's like a panel of 11, but you know, the Ninth Circuit's pretty big. But a big panel review it and say, this is the opinion of the entire Ninth Circuit. That's probably where the state of California is going to go from here before requesting certiorari from the Supreme Court of the United States. And en banc reviews, you know, typically it's a different standard of review. You know, is this, you know, are we creating a split within the Ninth Circuit, within ourselves? Do we have two conflicting opinions based because of what this panel said? I don't think we have that. Is this an issue of the utmost importance that, you know, warrants review? Maybe they try to say this is a public safety thing that they really need, you know, a solid opinion on from the entire Ninth Circuit. Maybe it falls in there, but ultimately, I don't think this is the end of the story.
No, look, crystal balling here. I very much believe that this particular case will be heard en banc. I do believe the Ninth Circuit will reverse when they hear it en banc, and then we will have to go deal with it at the Supreme Court level. Should the Supreme Court deign to let us bask in their light for another Second Amendment case, looking at you, Brett Kavanaugh, let's just hear it.
I'm giving him the benefit of the doubt.
You're giving him more benefit of the doubt than I am.
But,
I'm not happy.
But is this one of those kind of cases that the United States Supreme Court reviews? We're talking about a California law impacting wholly California. We're not looking at circuit splits on these things. You know, can the Supreme Court say, hey, look, you didn't faithfully apply New York State Rifle and Pistol Association v. Bruen? Yeah. But if the Ninth Circuit reverses this thing, well, before it even gets to the Supreme Court, I mean, it's going to get directed back down to the lower courts to refigure it out, go back and do it until you get it right. So, I mean, this is a long battle.
It's a long battle, and it's one that we're as likely to lose as win. I thought this was going to be more of an uplifting episode than it
I'm
turned out to
uplifted
be.
for the time being.
Yes.
For as long as it
Be
lasts.
temporarily uplifted.
It's like that client who is innocent for as long as it lasts.
Yeah. Who was that? Was that Rusty Hardin?
I think so.
Was it Rusty Hardin now? I can't remember who we attribute that quote to in Texas, but what we say is criminal defense attorneys when, you know, these things take a very long time to play out in the courtroom. We say that a reset is as good as a dismissal for as long as it lasts.
Yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And as always, please question and comment below. Until next time, we're the Armed Attorneys.